Division 1 is now in session.
Thanks. Everybody be seated. Good morning. We're here for our oral argument in RCV 240534, Date Street Capital LLC and Farmers Insurance Company of Arizona. As you know, you each get 20 minutes to make your argument. Appellant is in charge of keeping time. If you want to reserve some, just let us know. We are recording and live streaming this oral argument, so when you reach the podium, if you would just say your own name as well as the name of who you're representing, that would be helpful. And keep in mind that we have reviewed your briefs and the record, and we've conferenced this case this morning. And with that, you may proceed.
May it please the court, your honors. My name is Adam Decker. I'm the attorney for plaintiff appellant Date Street Capital. Depending on how this goes, I may reserve a couple minutes, but let's just see what questions that you have for me. This is a case that really stems from a automobile insurance policy and dispute arising from that. Date Street Capital is a purchase money lender and provides purchase money financing for buyers, used car and some new car buyers throughout the state of Arizona. One of its buyers, a gentleman named Kensel, who was a borrower and is also the insured in this case, a contingency upon any of the financing is that Date Street Capital, that the borrower becomes an insured, obtains an insurance policy, and that within that policy, Date Street Capital is identified as a lien holder and receives both on the declaration page, but then also receives protections afforded under loss payable clause as a loss payee.
And so we've read the briefs here. Can you talk about the difference between a simple payable loss clause and a standard clause? I think we all agree it's a simple.
Yes, I think that's the position that the lower court took, and I don't think that there's any evidence really for me to make a strong argument this is a standard clause where there would be direct rights under the contract between farmers and also Date Street Capital.
So if we don't have direct rights, then what do we do?
Then what?
Then what do we do?
Then what do we do? Yeah. So what are the rights? And I think that that's the law that's being developed here in Arizona, frankly, in the last couple of years by Date Street kind of asserting its positions to try to see which way the Court of Appeals will go in this development. They've been pretty broad as far as there's a narrow when you have a simple clause. I think the other jurisdictions will apply it very narrowly. There's been talk even a couple weeks ago I was down in Tucson, another appeals case where it's going to be only a limited right to payment. Other jurisdictions will expand that to where the lien holder is viewed as a third-party beneficiary. In this case, what's interesting are three different provisions in the policy, and it's what really is being bound, what is the insurance company being bound to, and are they really offering anything that they aren't already bound to do already? And those three provisions, the first is a payment of loss provision, which says we may settle any loss with the owner or the lien holder. The whole objective of the policy is to settle a loss. So for the insurance company to say we may, it's almost an illusory provision or an illusory statement or a statement without any real teeth, because they are obligated to settle a loss. That's the whole objective of why a policy was purchased and why the premiums were paid.
Well, isn't that one of two alternative provisions? They may settle it on this basis or something else. Isn't that the way the sentence is structured?
It says specifically, we may settle any loss with you, the owner or the lien holder of the property shown in the declaration page. The prior sentence, but I don't think it's a direct sentence, it's not the direct prior sentence, says, we may pay the loss in money or repair, replace damage or stolen property. But then I think there's some more sentences before it gets to that binding language there as far as.
But isn't the sentence you were referring to saying may appear to the named or may repair the car? I mean, the may is you have a choice about how you settle this claim, not you may pay out. It's that you may settle the claim by either paying out or repairing the car. I'm looking at, it's ROA 20 PDF 30, so, but it was the end of the sentence you started to read about how the may was illusory. May appear, shall be paid as interest may appear to the named insured and the lien holder shown on the declaration page or through the repair of the damaged car. So.
Yeah, well, and I guess that's what I'm trying to get to is what the may refers to. There's two that are identified. What I really want to focus on when we get there is loss payable clause, where we have. My point is this. The insurance companies know what's going to be interpreted by the courts and what's they're not going to be interpreted. And so they know that what needs to be in the policy provisions is things that look and sound and seem like, hey, these are binding provisions, when sometimes, or that they give a permissive decision to either go one way or the other, when really overall they're bound to pay. They're bound to protect the lien holder when there's a lien holder identified on the declaration page, and they're bound to protect the collateral. They're bound to protect the interest of the insured as well. My point in bringing up the may language as far as being a permissive statement in the payment of loss provision and also in the policy notices provision is that while they're saying we may provide notice, I'm trying to just broadly state that what they're doing is they're trying to protect themselves, the insurance companies, from any mistakes that may be made, whether they give notice or not. They really can't have their feet held to the fire because it's kind of their option to do whatever they want to.
Well, the issue is kind of that, you have a contract with your insured, Kensel, and you're requiring Kensel to adequately secure you, right? I mean, that's the point, is so you're protected, right?
Right.
So maybe your company shouldn't approve purchase agreements where the security has language in it like this. I mean, you have the right to disapprove that, but you entered into this agreement with Kensel to finance a vehicle when he went and had a contract with a third party that you're in here suing as opposed to Kensel, that you're saying basically doesn't adequately protect you. But isn't that really kind of a you problem for for letting him obtain insurance and green lighting that as the basis for the purchase agreement?
Well, I guess that's what we're here to determine. Whose problem is it? Is it the insurance problem?
But you had the right in the first place not to loan the money. Your client had the right not to finance a vehicle so tenuously secured, right?
Well, and if you go correct, and absolutely. And I guess the insurance company also has the right to put language in their loss payable clause that says, it is agreed that at our option, any payment for damage to the car listed in the policy shall be paid as interest may appear on the named to the named insured and the lien holder shown in the declarations page. Well, what is that option? If there's a loss, there really is no option for them to pay or not to pay. If there's a loss, they must pay for the damage. In this case, there's no dispute as to whether Kensel jeopardized coverage by doing something nefarious or something improper or illegal. There was coverage in this case, and because there was coverage, that coverage should have, at least depending on how you want to approach the simple loss payable clause, Your Honors, it's either a limited right just to receive payment, or it may be more right as a third-party beneficiary. But let's say it's only that right just to receive payment. That's all that Date Street has. This language, again, is an illusory provision. It is agreed that at our option, any payment for damage will be paid to, it doesn't say the insured or the lien holder, it says and the lien holder. So what is this option that they're talking about? The option is language that's pre-baked in there simply to protect them, but it makes no sense.
I actually think Judge Hanna's decision in the trial court, which was in these materials, made a lot of sense because he was saying that it required payment sort of in equal proportion of whatever the rateable interest is, that, like insured has this much of the interest, you have that much of the interest, they have to suss it out and pay that proportionally. I thought that was a pretty reasonable construction of the contract, no?
Well, I did too, but.
So that doesn't sound illusory. Wait.
But the court in Tucson didn't, if you didn't see the decision recently.
No, you said it did sound logical. So that doesn't sound like an illusory promise. I mean, you and I both agree there's a reasonable construction of that language that is not illusory or completely disadvantageous to your client.
Well, it's disadvantageous when they say we're going to pay both. If we're going to make a payment, we're going to pay not either or, but they use the language, farmers use the language and.
Well,
they use that conjunction.
Other than trying to establish more favorable insurance law in Arizona for your client, which, Godspeed you have all rights to try to do that, why not just proceed against Kensel? I mean, wouldn't that be the more logical play here?
Absolutely.
But why not then? Why
there's no recovery.
Because Kensel spent the money?
He spent the money and he's MIA. And it's really about it's the election of who to go. I'm going to be completely forthright with you. It's really about the pursuit. And I'll be even further forthright. My client's not sitting here saying, hey, let's go out and let's reestablish law for all the lien holders out there. Our objective would be to try to sell these cases. And what we're doing really is, as the courts are developing the law, whether memorandum decisions or actual opinions, what we're doing from our perspective as a business advantage is saying, okay, well, how are we going to now treat these type of cases? And maybe we need to lower our expectations, or maybe we need to focus here or there when we're doing our negotiations, or what lawsuits get filed, what lawsuits don't get filed, because it's really been kind of the Wild West in Arizona as it pertains to what the rights are.
Don't you want to write your contract in such a way that your client isn't left to the vagaries of what a court decides? I mean, it seems like my limited understanding of this area of the law is you're better off with a standard loss payable clause than a simple clause, and you wrote that. I mean, so aren't you kind of stuck with that?
Well, and there's no evidence at the trial court, so I don't want to, I guess I have to kind of just, in response to what you're saying, and I've been heavily involved with Date Street in much of these cases. Standard provisions are not necessarily those aren't offered provisions in these contexts. Okay, a standard loss payable clause when it comes to insurance policy. That's just not what the market is providing. I'll even go so far as to admit that when I was down in Tucson a week and a half ago, one of the judges invited me to expound upon why not just make them, rather than loss pay, an additional insured. That's just not what's in this industry. That's not what we're seeing in this industry.
Well, if that's the case, don't you just accept the occasional losses that are going to happen, and this might be one of them? Well,
we may have to. I mean, that may be where this is going. If the Arizona courts are going to interpret these type of policies as a limited basis to receive payment, and that we're not going to expand and look at the policy arguments surrounding them, because it's really difficult to find any type of ambiguity in the policy terms, so we can't get through the door to actually look at what the policy arguments are, how this type of behavior by farmers and only paying the insured rather than the lien holder actually goes to the detriment of the insured, because that just increases the liability potentially increases the liability, where the purpose of this policy is to offer a myriad of protections. It protects the collateral, it protects the overall liability under the loan. It does protect the consumer. And when the consumer is able to cash a check without and pocket the money, it's only hurting itself. And while those are broad ideas and broad notions, when we get back to this specific loss payable clause, what I'm trying to say is that when it says it is agreed that our option, that means nothing, because their only option when there's a loss in this case is to make a payment. And that payment is to be to both the insured and the lien holder. There's nothing there that says we'll pay one or the other, and they went ahead and paid one or the other. And I know this is new ground. I mean, I can only find one case that was not directly on point, which is a South Carolina case throughout the U.S. But that's my focus here as it pertains today, is that what farmers should have done if we're going to look at its policy. Never mind public policy arguments or the way that things are done in the marketplace. Under the direct language here, that phrase at our option, whether it's ambiguous, illusory, it doesn't really matter, because they don't have an option. When there's a loss that's covered, they have to pay, and by the agreement's own terms, they pay both.
What's your best argument that notwithstanding you've admitted up and down that this is a simple policy that you nonetheless should be able to recover? And you started off, we interrupted you, I apologize. You started off kind of explaining a continuum where, like, on one hand, third-party beneficiary, I wrote down, seemed to be really broad, and then you used the phrase a narrow right to payment. What's your argument that this is somehow like the narrow little case that somehow should lead us to say, with a simple policy, you're entitled to reach in and have rights? What's your best position on that?
Well, I think I just argued it.
Okay.
And so I don't know, so clearly it wasn't overly impressive if you're saying that's what's your best argument, that's what I'm coming at with
I'm sure
you.
you had a chance to answer that.
No, I know, I'm following you. Let me focus again on what you just said so I can reiterate when we're talking about the narrow versus the more broader third-party beneficiary. With the third-party beneficiary cases that are out there in the jurisdictions, what those jurisdictions are saying is that, okay, you may not have a direct contract claim, but you certainly have a claim for declaratory relief, and you have a claim as a third-party beneficiary because you're identified on the deck page, and then if the terms of the policy are a little bit loosey-goosey, doesn't matter. We're going to still find a way to find some protection for the loss for the lien holder, because the industry isn't providing for additional insureds. It's not providing any further for standard policies. It's these simple policies. Languages are everywhere. So that's the broader jurisdictions. The more narrow jurisdictions are, you don't really even have rights as a third-party beneficiary. You only have derivative rights, which are rights to payment and nothing else. Mm-hmm. And that's kind of where we're headed right now as far as what happened in Tucson. And
it came out Friday.
Yeah, it just came out Friday. And in that case, there's no right to the appraisal. And so what the Tucson court's saying is that, hey, whatever the insurance companies want to set as far as the valuation, lien holder, you get what you get, you don't throw a fit. And that's it. And that's so I think the best argument though in this case is what I've just identified, which is there really is no option. They have to pay. Any other questions? I'll reserve some time. All right, thank you.
When you're ready.
Good morning, Your Honors, and may it please the Court. My name is Ashley Caballero Daltrey, and I represent the defendant in this case, Farmers Insurance Company of Arizona. Date Street is not a party to a contract with farmers, but it seeks to hold farmers liable based on the loss payee clause in the contract that we've been talking about.
Hey, excuse me, could I jump in? We'll get there in just a second. Don't they at least have standing, even under, your theory of this case, really? Haven't they alleged a particularized injury because they have collateral at least?
I don't believe so, Your Honor, because under Arizona law, a non-contracting party cannot sue an insurance company, and that's long-standing Arizona law. And this isn't the sort of prudential argument that we see in taxpayer standing, for example, or environmental cases. This has to do with contract law and who is a party to the contract. And this case, in the Date Street versus Clearcover decision, in fact, specifically discussed standing. It mentioned that whether Date Street had standing to sue, whether it was in contractual privity with Clearcover, and whether it had a legally cognizable claim, all turned on the existence and nature of the loss payable clause. That's in paragraph 14 of the Clearcover decision.
Standing, the doctrine of standing in Arizona is generally a fairly relaxed one that requires the articulation of a particularized injury. I mean, I understand what you're saying, but it kind of collapses whether you have a valid contract claim. It collapses standing into whether you have a valid contract claim. There's no airspace between those ideas, the way I hear you describing it.
Under Arizona law, that is the case for insurance contracts, I think. The cases continually talk about the fact that a non-party doesn't have a right to sue, and if they don't have the right to sue, they don't have standing. And I think that follows contract law in general, which is very clear about the intent of the parties and the actual contracting parties who sign the contract. And that's especially the case in insurance law, because an insurer has the right to know who they're insuring and what they're insuring, which is also why Arizona law generally does not allow assignment of insurance contracts pre-loss.
So if you have a claim under the contract, you have standing. If you don't have a claim under the contract, you don't have standing. At least I'm interpreting Judge Jacob's comment that they're more or less the same question.
You start to get into differentiation when you have things like a standard loss payable clause. You can have standing under a standard loss payable clause. If a party is a third-party beneficiary, you could have standing in that regard. So it's not limited to just whose name is on the contract, but sort of these different theories of how did you become in privity, because you can't be injured under the contract, that basic tenet of standing, unless you're actually a party to the contract, unless you have some privity with the contract. So, for example, in the clear cover decision, this court held that there's standing for a standard loss payable clause because in those clauses, the loss payee is insulated from misrepresentation, fraud, or intentional acts of the insured. In other words, the contract in a standard loss payable clause assigns the contract and those benefits to the lien holder.
Clear cover is not a published case. And is a third-party beneficiary in privity then, in your view of it?
Such that it would have standing, yes, Your
No,
Honor.
you're saying they have standing, but is a third-party beneficiary truly in contractual privity with you? Is that the same thing as privity? You just equated standing with privity. As a third-party beneficiary such an entity?
Such that that person is able to sue if they are, under Arizona law, the primary beneficiary, that the parties intended to benefit such that that person acts in privity. Yes, under Arizona law, the third-party beneficiary is essentially in privity with the contract. I do want to note, however, the clear cover decision is published.
Oh, I'm sorry.
Yes, the clear cover one is a published opinion. There are 3 additional memorandum decisions involving State Street.
You're right, I apologize. Thanks.
So let's turn then to the clear cover decision. The clear cover decision created a clear dichotomy between the standard and simple loss payable clauses. Throughout the decision, it continued to talk about standing, contractual privity, cognizable claims. It followed the logic of mortgage law cases where the standard and simple designation already existed under Arizona law. So although the clear cover decision is the first one to bring this up in the automobile context, like this case, it followed Arizona law that has existed for decades on mortgage clauses. There's no argument as to why clear cover was incorrectly decided. State Street argued in its brief that it simply didn't reach simple loss payable clauses, but I think it's clear from the decision that there is a dichotomy. They're trying to give direction to the trial court on remand so that it knew what to do when it read the loss payable clause because the contract hadn't been included at any point in the trial court.
What about his point that you didn't do what your contract says? Setting aside for a moment, the point you've just made, which is a strong argument, did your company actually follow the language of its policy with Kensel here in issuing the payment the way it did?
Yes, Your Honor, because it is at our option, and we need to read the loss payable clause in context with the other provisions of the contract, some of which State Street mentioned in its argument that talk about we may pay the lien holder or you, the insured. And so I think when read as a whole, the policy shows that it is farmer's option whether to issue the check jointly or separately as to State Street or to the insured. But I don't think we have to reach that issue. This court doesn't need to get that far because it can decide on the clear, bright line standing rule following clear cover.
So just to make sure we understand, assuming that you're right about standing, it really doesn't matter whether you followed the contractual language in the policy, is kind of what you just said, right?
Yes, Your Honor, but we did follow the contractual language, but it doesn't matter if they don't have standing because they cannot reach that issue. So State Street also talked about this continuum from the narrow derivative clauses for simple loss payable clauses and the third-party beneficiary status that could be conferred in some jurisdictions. Arizona law doesn't follow those jurisdictions. Again, clear cover started from the mortgage law context, so we already had a framework for how Arizona analyzes simple versus standard clauses. And in clear cover, in a footnote, the court talked about simple loss payable clauses and the fact that under Arizona law, those are derivative. So we really are starting at the narrow end of the continuum under the mortgage law and now brought over to the automobile context where this is derivative rights. They're a mere appointee is the language that some of the Arizona cases have used. And State Street briefed the third-party beneficiary issue and the out-of-jurisdiction cases in the clear cover case. So those arguments, and those cases have already been before this court and have been rejected, and those cases and arguments were also raised in the memorandum decision Date Street cases, where again, this court declined to pick up the idea that a simple loss payable clause would create a third-party beneficiary status. And I recognize that Clear Cover doesn't directly address that, but if every simple loss payable clause created the third-party beneficiary status for the loss payee, then there would have been no reason to create that dichotomy, because the court could have said, a standard loss payable clause confers standing, but a simple loss payable clause will always create a third-party beneficiary, such that the simple loss payable clause also creates standing. So it would have been easy to, on remand, say, either way, Date Street has standing, now the court can move forward to addressing the merits. But the court had to give guidance to the trial court to say, here's how you decide if they're standing. It didn't just wholesale determine that there would be standing under either version. And that also tracks Arizona law on third-party beneficiaries. As we discussed earlier, a third-party beneficiary is essentially in privity of contract with the contracting parties. The third-party beneficiary has to be not necessarily identified by name, though usually by name, and the contract is intended to benefit that person as the primary person. And it's clear in simple loss payable clauses that it's not intended to benefit that lien holder, because the lien holder's rights are derivative. The lien holder isn't even protected in the case of fraud, misrepresentation, or intentional acts of the insured. The other thing that Clear Cover says, though, in passing is perhaps if there is an assignment, then there might be standing. Now, the Clear Cover discusses assignment in two ways. First of all, as we've discussed, the standard loss payable clause is essentially an assignment of the rights, because under the contract, under a standard clause, the loss payee is protected. But there is a comment in Clear Cover that perhaps if there was an assignment of in another way outside of the loss payable clause, that perhaps that person would have standing. And in the reply brief for the first time, Date Street raised two arguments regarding assignment. One is that the purchase agreement assigned the rights to Date Street, and the other is that equity could assign the contract to Date Street. I do want to clear up the record on that issue because
Were those issues litigated below assignment?
the issue was never raised below, and that's exactly what I wanted to address, because I do want to clear the record. Farmers asserted in its motion to dismiss that there was no allegation regarding assignment. There is, in fact, an allegation regarding assignment that's in the first amended complaint at paragraph 15. Farmers inadvertently overlooked it because it's in the middle of the paragraph, but it asserted that there was no assignment in this case in its motion to dismiss, which was not addressed in the response. It asserted it again in reply. It was raised at oral argument. There was no discussion of it at oral argument. The court below did not discuss assignment. There was no motion for reconsideration. On appeal, the only issue that Date Street raised was the loss payable clause. It did not raise as an issue the assignment concern, and in the facts section, there's no discussion of assignment. So it's our belief that that argument has been waived at this point, and really it deprived farmers the opportunity to clarify that issue. And what farmers would have argued if it understood that that was part of Date Street's argument is that that assignment is invalid under Arizona law. Arizona law has long held that you cannot assign an insurance policy. For example, Aetna Casualty and Surety Co. versus Valley National Bank, that's 15 ARIS App 13, discussed that you cannot assign pre-loss an insurance policy, which is exactly what was alleged here, that Kensel in the purchase agreement assigned his rights to the policy to Date Street. That's an invalid assignment under Arizona law. And so even if this court doesn't consider that argument waived, it should still find that there was no valid assignment, and without a valid assignment, we're right back at the loss payable provision.
I just want to really compliment your explanation of this. You unpacked that very well. But there is like sort of a little contradiction maybe in your argument, or maybe not a contradiction. I'd like to ask you to explain. you said that it was hinted at in clear cover that there were two possible bases for assignment. One, the purchase agreement assigns the rights to Date Street. Two, equity assigns the rights to Date Street. But then it seems like you circled back about a minute and a half later and said, but Arizona law wouldn't let that be true anyway. So you're saying that the door that clear cover was like poking open, that's other case law contradicts it, is what you're saying, right?
There is a limited ability to assign an insurance policy post-loss, and I think that's what clear cover was referring to.
Okay, so, but what about the equity theory? Where does that fit into what you're saying?
Clear cover did mention equity. It did not describe when equity might apply. The case that it cites, Allen, is an old case from the 1930s involving a title and trust and insurance company. And in that case, one of the parties had written a note to the insurance company that said, I would like to give the proceeds of my mortgage, like $200 a month, to this lumber company. And the case was between the lumber company and the person who had written that note. And so there was an argument that there was an assignment in equity, that because when the insurance company paid the person who pay the lumber company instead, they gave him the check, that he was essentially the trustee who needed to hold on to that money only for the lumber company, as evidenced by this whole note process of pay my mortgage to the lumber company. So it wasn't against an insurance company.
Let me pause you. That's a very helpful explanation, but to be the devil's advocate, or to be Date Street's advocate on this matter, why, if his characterization of the loss payable clause is correct, then why wouldn't that stand in for that little note you described in this 90-year-old case about the lumber company? Because, I mean, it seems like the purpose of the exercise is to allow Date Street to recover money. Your policy talks about payment, and it seems like Kensel was supposed to obtain the ability for them to get payment. So why wouldn't it be analogous to that equitable case?
The analogy would be that then Date Street would sue Kensel because the insurance company wasn't party to the Allen case. And that predates a lot of this discussion because it was from the 1930s that insurance cases or insurance policies are generally not assignable. It didn't take into account the case law regarding that non-parties to an insurance policy could sue.
That makes it all the more striking that ClearCover, a recently published case, sort of invoked equity as a possible exception that would allow them to come through the door and have standing in your rubric and obtain recovery. I mean, it seems like our court is a little bit troubled by the fact that there's no recovery for the entity that's securing the transaction.
I have two answers to that question. So the first answer is, to the extent that the court is a little bit troubled, I think that has to be read in the context of standard loss payable clauses, because much of ClearCover discusses explicitly standard loss payable clauses, and when it talks about how Date Street might have been like an injured person in the ClearCover case, it's specifically in the context of standard clauses. So I think we have to read some of that in terms of this split. And the second answer is that if we allow equity to assign contracts in this scenario, we are essentially letting the exception swallow the rule at that point, because at any point a court could fashion an equitable remedy to allow a post-loss or even pre-loss assignment that would undo these decades of insurance law saying that you cannot assign an insurance contract, especially where there's an anti-assignment provision, like there is in this case. That's at Index of Record 22, Date Street CF 25, the Bates number on there. And interest in this policy may not be assigned without our written consent. We would start to undo the basic fundamentals of insurance contracting by allowing equity to step in and fashion a new remedy. And that's really contrary to the whole point of contracting. We write contracts and we have clear descriptions in contracts specifically so that the parties can decide what their rights are, that they can bargain for those rights, and that's what should have happened in this case, and I think it would be inappropriate for equity to step in and try and fashion a different remedy. And also, that argument was raised for the first time in the reply brief. We believe it's waived. There's not a single case citation in the reply brief where equity was ever used to assign an insurance contract in a case like this. And even reading that argument, Date Street's only argument is that the loss payable clause itself is the reason for the assignment in equity, which would undermine, again, the ClearCover decision because it wouldn't have needed to create that dichotomy. So I think there's a lot of reasons in this case not to apply equity.
can suppliers would you welcome that we publish our opinion in this case?
I think that you should, Your Honor, because although Farmers believes that the clear cover case was clearly articulated the difference between standard and simple clauses, as you saw in the briefing, a lot of the argument was that clear cover was not definite enough and didn't say specifically a simple loss payable clause does not have standing. That line does not exist in the opinion, although it's pretty clear from the structure of the opinion. So I think this would be a very good case to publish an opinion and to clarify that law for future litigants. I just want to briefly touch upon counts 2 through 5 in the complaint. That's the breach of contract, bad faith, third-party beneficiary, and implied contract. Date Street has never advanced any specific arguments to those. All of its standing arguments have been about the declaratory action in this case. It seems like those claims were raised in part as alternative theories, especially the third-party beneficiary and the implied contract. But there's never been any argument as to the implied contract or any separate argument as to why Date Street might be a third-party beneficiary outside of the loss payable clause. So even when we're looking at those claims, we're still, the only theory that they've advanced is that the loss payable clause would give them standing for those additional claims. And because they haven't made any argument, even if they have standing, it should be limited to the declaratory relief action only. That's count 1. So then on the declaratory relief action, there was also a little bit of confusion in the brief. Farmer's argument is not that there's separately no standing for any part of the declaratory action claim, but that if there is standing, it can only be to declare the rights of the parties. For example, one of the declarations that Date Street seeks is that farmers must pay $17,000 and something. That's a claim for monetary relief. That's not a declaration of rights. That's just a declaration that farmers has to pay a specific amount of money. So even if there's standing, which again we don't believe that there is, it should be limited only to the declaratory action and only to the parts of that relief that would actually declare the parties and not those parts that would declare that farmers must pay some monetary amount. So for these reasons, we ask that you affirm the trial court's decision in this case dismissing plaintiff's claims. Thank you.
Thank you.
Yeah, counsel, I'd have 2 questions for you right off the bat.
Okay, and then I've got a summary, so let's hit your questions the best we can.
Yeah, so first, with respect to the last thing, I thought we were just talking about your deck action here. I didn't think we were talking about counts 2 through 5. Comment?
I'll maintain the same arguments and analysis offered in the reply brief, which is that they were not necessarily focused on by the lower court. There was nothing in the motion to dismiss that I think addressed those counts. And so whatever we have adopted and whatever I had in the reply brief, I would adopt, Your Honor, to answer that question.
So you're treating it as one thing. I mean, in concept, those counts are the same arguments you've made.
Yes, Your Honor. Yeah.
Okay. And second of all, why isn't your opposing counsel right that you've waived this assignment theory sort of up and down? It seems very clear from her close articulation of it that you have.
No, I think she did a great job. And
Did she write that you waived it? I mean, is it a new argument that you want us to reach even though it's waived?
I would agree that Arizona law, that the assignments are permitted after loss, but prior to loss you can't negotiate an assignment. And so I would agree upon further review, post this reply, post my briefing in advance of this oral argument, that the assignment in the purchase contract wouldn't be a proper assignment. I wouldn't give away the equitable assignment, though. I think the clerk of the court did open the door.
But you didn't raise it until the reply brief in this court. That's what we're talking about. Do you agree with that or not?
I agree that on that specific question, I did not raise it until the reply brief.
Okay, very good. Thanks.
In the part in 2 minutes, the main thing I'm going to focus on is this: is what Farmers is arguing, and then what the lower court also accepted. Is too far-reaching. It's that a lien holder, particularly Date Street, is a non-party to the policy. And I would invite, and as a follow-up to from Judge Ho's question, a published opinion I think would be proper in this case. We need, I think, in Arizona, not just for the high-risk lenders or the closely held lenders like Date Street, but also for credit unions and also national lenders that are providing purchase money loans. Under a simple loss payable clause, if the court were to adopt the lower court's ruling and find that there's a non-party, then really what are the rights of a lien holder in a simple loss payable clause when they are not paid or when the insurance company fails to follow the policy? They're not third-party beneficiaries, they're not parties, they don't have standing, is what Farmers is arguing. There has to be some avenue or some method that lien holders, when insurance companies choose not to pay under loss payable clauses, have a right to keep those keep the insurance companies accountable, or at least to present the issue.
If we agree with you that you have standing, but we agree with your opposing counsel about everything else, is there anything new to be said that wasn't already said in clear cover?
I think a greater, yes, because I agree with what counsel said. The clear cover does a very good job of elaborating upon what a standard clause would be in Arizona, but that's just not what the industry is. I mean, the industry are simple loss payable clauses, so some clear lines of and earmarks about how they're to be interpreted and applied, and what the rights are of lien holders under simple clauses, I think would be very beneficial. I don't think clear cover is enough. I think we need more.
Thank you. Thank you, counsel, for your arguments. We will take the matter under advisement and issue a decision in due course, and we're adjourned. Thanks.
Thanks.